What's up everyone? Welcome back to the channel. Today's lineup is packed with courtroom chaos, and we are kicking things off with a guy who might actually be competing with Eric Martin for the title of most ridiculous sovereign citizen alive. If you're new here, allow me to introduce the legend himself, Dan McCoo. Trust me, this one only gets crazier from here. Let's jump right into it.
Does call the case of the People versus Daniel McCoo. State your name.
Daniel McCoo.
All right. What are we doing on this today?
Your Honor, I have in regards to case number 25F4-523, I have a couple things I'd like to point out about a couple of the matters here today.
Right.
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that charge is invalid on its face. That were going to be
addressed. That would be addressed at the preliminary examination, sir, as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion's denied.
Okay. Further in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenge the prosecutor to prove all 3.
Sir,
yes,
do you wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting that all the charges are dismissed, a motion for all dismissal on all these charges.
You can demand a dismissal all day long, but Judge Simpson has seen this routine before. After watching you stall, argue, and play games with the court time and time again, there's basically zero chance he's suddenly going to throw the case out just because you insist he should.
They're not going to be dismissed.
No, okay.
So if you want a preliminary examination and make your arguments, then it might be that they would be dismissed at that point, but they're not going to be dismissed on an oral motion before this.
Okay, Ms. Lomby has let me know that all paper discovery has been sent to Mr. McCoo in jail. There are USB drives with video. A number of agencies were involved in the Michigan State Police case, so they responded to assist. I believe she has obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. McCoo, and I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten the video.
He has all paper discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure.
So, Mr. McCoo, are you going to have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So given that that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to a
All right.
speedy
So
trial.
you want your preliminary examination. Those are coming down to the jail to him.
I expect that you would have them early next week, so if the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th, and then
Have them as well.
he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination as being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Mr. Magoo, you are before the court on a felony complaint that alleges 5 different counts, excuse me, fleeing and eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court cost, and your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court cost. Those events are alleged to have occurred on July 3rd, 2025. I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a third offense notice which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively. And 60 to 180 days community service, any rehabilitative programs the court deems necessary. Court could order you to pay the cost of the prosecution, plus cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody, or escape from lawful custody, excuse me. That's a misdemeanor, punishable by up to 1 year, $1,000 fine plus court cost. Mr. Magoo, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I do. I will. I have requested assistance, given that I am incarcerated and I have no way to.
Do you wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be represented by?
I've called the prosecutor.
Mr. Magoo, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you. That is a yes or no.
I would like legal assistance, yes, Your Honor.
Well, that might actually be the first reasonable decision he's made in a very long time. Maybe he's not quite operating at Eric Martin levels after all, although that haircut is still making a pretty strong argument against him.
I'm going to take that as your request for counsel, is how I'm going to take that. And so these two cases now become public defender cases.
Thank you, Judge. Torture Officer, Assistant Public Defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
I will set, he's asked for examination in the case, and so I will set these for preliminary examination.
Okay.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Levasco, People versus Bassard, People versus Rosengreen, and procedural unfairness, Sixth Amendment violations. And I do request that the prosecutor provide provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. And I'm just requesting that the court grant a personal reconnaissance on my behalf. And for both of these charges, being that we're looking at really just misdemeanors, $500 misdemeanors.
But these aren't simple misdemeanor charges anymore. Since this would be your third DUI offense, the situation changes completely. If you're found guilty, the charge can be upgraded to a felony, which brings much more serious consequences with it.
I think he's requesting, Your Honor, amend his bond, and he's requesting a release, Your Honor, PR bond.
In response from the people regarding his bond.
People would ask the bond to continue, and he also at the bench for failed to appear before the judge's place. So
yes,
that warrant would also hold up with respect to the other I'll wait. There are pleadings filed by the defender's office. Our office will respond to that. And I guess my one remaining point would be, should with the court's appointment Eastern the public defender's office, I will make sure that the digital discovery that I referenced is certified on the defender's office.
Yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still being held, regardless of what the bond would. In this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That his bond has been denied. So
that's what I would Mr. Trevor said.
In any event, but also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in his bond in this case, that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And
I understand the presumption of innocence.
and a lot of these are facially invalid, Your Honor.
Excuse me?
A lot of these charges, especially custody, escape from lawful custody, it's facially invalid. I was at a hospital, not a jail.
If you were under the custody of the Washtenaw County Sheriff's
I was
Office,
not.
I understand.
I was not.
Or custody of.
I was dropped off at the hospital and they later tacked on
And
charges,
you know
just
what?
like the fleeing and
evidence
eluding
will
charge.
Not meet that out. And that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not dismissing it upon your representation today.
In plain English, the judge isn't buying a single word of your story, and your bond conditions are staying exactly the way they are.
Thank you very much, Judge.
Preliminary examination in this matter will be set August 19th, 2025, 12 noon. That is before me on that date for both of these cases. I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh yeah, in that regard, Your Honor,
Many of those, do not interrupt me. Including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with court. I consider it, quite frankly, to be frivolous. Complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen, and that is attempting to manipulate the system. He will be dealt with by me as I deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for the Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there, they will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people of individuals without specific reference in the Washtenaw County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So.
I'm aware of such filings were being received by our office maybe yesterday. At this point, we continue to proceed with this case until I hear otherwise from the elected prosecutor.
can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here, as it was in the past before this complaint. And I do request a change of venue on that note for both these matters.
If you wish to raise change of venue, you may file that in writing, but to the extent you are raising no motion for change of venue, denied.
Thank you very much, Judge.
Bond will continue. Thank you.
All right, that wraps up that hearing. And judging by how things went, Dan McCoo won't be walking free anytime soon. Looks like he'll be spending the weekend cooking up another ridiculous lawsuit against everyone involved in the case, probably including Judge Simpson himself. Now it's time to move on to our next courtroom disaster, a full-blown Karen who keeps threatening her neighbor both online and face-to-face, yet somehow still believes the protective order against her should be lifted. This should go about as well as you'd expect.
We are here in the case of Darnell Gay versus Renee Campbell, case number 25-05147PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on Ms. Campbell's request to terminate the personal protective order that I granted in favor of Ms. Gay back on June 14th of 2025. I do have to tell you, both ladies, and apologize in advance. I have gotten us behind just through my fault and my failure to move these cases as fast as I'm supposed to move them this afternoon. So I'm a little bit short on time. I don't have time to take extensive testimony on it. I think what I'd like to do is let me see here. Okay, so we're just going to have to keep it quite short. And I guess the way I'll do it is I'll swear in Ms. Gay, take her testimony as to the basis for the PPO. I will hear in a response from Ms. Campbell why I should terminate the PPO, and then I can make a ruling. So, Ms. Gay, if you would please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do.
Very good. And to support this protective order, you stated that there were a couple of incidents here, one of them being Ms. Campbell throwing eggs at your house. Tell me what happened on that occasion.
After the incident happened, after the altercation with, her and everybody else on the Hall Street,
Yes.
They threw eggs at my home.
Was
and
it
then
during that same big brouhaha and the blow up, or was it later that day or in the evening? When did it happen?
later.
Okay.
And
All right.
then
And who are the egg throwers that you saw?
Renee and her daughter.
And you saw them actually throw eggs at your house?
Yes, because the next day she was on the neighbor's porch, just keep yelling. I didn't throw eggs. I have cameras all around my home, all around it. And I have my cameras, if you come anywhere towards my perimeter of my property, it captures you. It was her and her daughter. They were throwing eggs. And then the next day she was on the neighbors on their porch, just constantly yelling at my house. I've never had a conversation with her yelling. I haven't thrown.
Yeah, maybe don't throw eggs at your neighbor's house. And definitely don't bring your daughter along for it. It gets even worse when the neighbor has security cameras capturing the whole thing in HD from multiple angles. And honestly, with egg prices these days, you're basically committing a drive-by attack with luxury items. At that point, you're not tossing eggs. You're hurling liquid gold at somebody's siding.
And then therefore, after that, every single day, she was yelling and screaming how she should have killed me. She would have shot me. I had friends calling me because she kept on going online and live streaming how she should have hurt me if I didn't have cameras at my house. And I did submit those. And I was also on the phone with the police on one of the incidents when she was yelling and screaming how she was going to kill me. And I also have a video of her personally, as well as someone sent me one when they were calling me out of concern because of her threats to harm me.
Okay. And my next question, you said you submitted the films. You submitted them to the police department?
Yes, I did. The lives that people were sending me, as soon as they sent them to me with her ranting and raving about how she was going to kill me, I went right downtown to the police department and I sent it to them. That's two of her telling me she's going to threaten me. I got one actually with her video, and I have her ranting in the backyard, just yelling and screaming and scaring my grandkids, telling them that how she's going to hurt me. And it just went on and on. And I have witnesses, guests over like, oh my God, you have to listen to that? I'm like, yes. She keeps threatening me.
Let me see what Ms. Campbell has to say about it. Ms. Campbell, would you please raise your right hand?
Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, I do.
Very good. Ms. Campbell, you
Well-
say in your response here, you think there should be a termination. It does say you're off probation. What were you on probation for?
I was on probation for the incident with her daughter and stuff, and ever since I've been off probation, she's been harassing me and my I have an 18-year-old daughter, and so she has a daughter that's my age or whatever, and stuff. So basically, ever since that incident, she's now that her daughter, so she basically got her daughter, her grandkids, and like her nieces and them making up stuff. I never once threw eggs at her house. I never said nothing to her. She came to my house, her and her daughter and her grandkids. I
Hang on,
never
you gotta let her testify, Ms. Gay, and then I'll give you a chance to respond.
now since she came to my house, that was May 31st. I have two incidents from this year. May 31st, which I put in the police reports, in February 9th, which was the Super Bowl weekend.
Like the judge already explained, the protective order went into effect back in June. So anything you're trying to bring up from before that point has nothing to do with the current issue and isn't going to help your case at all.
She has cameras. I've been living over here for 3 years. I never she has ring cameras and everything. I never said nothing before then, and I never said nothing after. She's just trying to prolong it because now that she wants to get in the mess with her daughter and her grandkids. Now she's trying to say this and that or whatever and stuff. And that was she made the PPO what June, May. My daughter's birthday was May 25th. So it was sometime after, like, then in July, in June or something. That's when she's making these reports. I never threw eggs at her house or whatever, and I would never tell my 18-year-old daughter to throw eggs at her house. She said she never called the police. If I threw eggs at her house, why didn't she call the police? She came over here with a mob of people, her whole generation and stuff. It's only me and my daughter and my 9-year-old daughter. You look, I have a 9-year-old daughter and an 18-year-old. Today, my daughter turned 19, so they're 10 years apart. That's not true. I never said I left in an ambulance. They assaulted me, her and her kids. And she has the background. You can look on the camera. She drove her car over to my house. I never once went over to her house. She
Well,
came over
you're
to,
talking about the big fight that happened in the street on Zeno Street?
it didn't have it happened on Hall Street, not
Or Hall
Zeno.
Street? Okay.
Yes, she came over. Her family came over to my
Yeah, I
house.
don't want to reissue the fight because she's saying, well, since that fight, this
Nothing never
thing
happened.
escalated.
Since after that, yes, she's been calling CPS. They've been calling the city. They've been calling, making, now she's trying to do a PP and fearing her life or whatever. Lady, I've been staying here for 3 years. I never, come on now. I never said nothing to her. I never, some eggs.
You're not yelling at her from the back porch where she could
No,
hear from her
no,
house.
I am not. You can ask the judge. You can get active and come to the neighborhood. I've been staying here. They saying that me and my kids, now she's going around saying my 9-year-old daughter with a taser. They brought the taser to the fight, and then my 9-year-old daughter
Yeah,
picked it
well, the
up.
taser's not part of this PPO,
I
so
know,
I'm gonna
but this
leave
is
that thing
it. But it
alone.
was led up to, is what leading up
Yeah,
to this
I get
mess
it.
or whatever and stuff. I
Let me
never
bounce
said
back to
nothing.
Miss Gay and I ask her about that. Miss Gay, have you been making CPS calls about Miss Campbell's parenting?
I have never called CPS. Miss Campbell, Judge, I have proof of everything that I've submitted. I have proof of her. I have My ring camera is what her coming in the backyard yet threatening me. I also have her on Facebook. I have all of the recordings as far as her talking about. I came around and Miss Campbell don't understand and she doesn't want to tell the truth. When I came around there, I tried to ask them not to have any altercation, and she keeps making up this stuff like nobody wants to harm her. I don't have no business like messing with her, and she doesn't have any messing with me. I'm not that type of person. She was found guilty for whatever reason with her and my daughter. I don't get in that stuff. I'm a whole grown person and an individual. I ask that you please keep this granted, because ever since you've granted this PPO, the yelling has stopped. I have not been threatened. She has not been online posting things about me. So I ask you, please, for my safety, because I don't need this unstableness, because I can prove it to you. I don't have to keep making up. I got video of everything that I'm saying.
There are really two important points here. First, the protective order actually seems to be doing its job. If the situation has calmed down since it was put in place, then it makes sense why she'd want to keep it active. But second, a protective order isn't something the court can extend automatically just because someone asks. It places legal restrictions on another person's freedoms, including where they can go and who they can contact. Because of that, the judge needs actual evidence showing the order still needs to remain in effect. Now, she says she has video proof to support her claims, which could absolutely matter. The problem is that she wasn't able to properly present that evidence to the court today.
Okay, no, I think what I'm going to have to do is I can't tell, you're both telling me really the opposite things, that, the other person's the instigator here. And in this format, without seeing the video evidence and things like that, I really don't feel like I can make a decision on the termination. So what I'm going to have to do is I'm going to adjourn this hearing to a future date. And my question to you then, Miss Gay, is to show me those videos. Would you be able to do it in a Zoom format like this, or are you going to need to come to the courtroom?
I can, I don't know how you do it on Zoom. I can even send it to you via email. I have
You can send me the files via email?
Yes, I can. If you give me an email address, I'll send it to you right away, sir.
Okay, let's do it that way, and then I'll have a look at them, and I can also email them then to Miss Campbell so she can look at them, and then we'll have them ahead of the next hearing. Miss Campbell, did you have a question or something to say? You're muted, ma'am.
I have evidence too, sir, and I would like to present the evidence, which she should have been presented the evidence. She been did this in June, so why didn't she present the evidence? Basically,
Well, she
her
sent it
daughter
with the
is
police
coaching her.
report, but
Basically,
I
her
can't get
daughter.
it. I can't look at it. If she submitted to the police download, they do have an evidence.com site, but it's not something that I can easily access. It's just easier for her to submit it directly. Because really it's a separate case. This is a civil case. It's got nothing to do with criminal activity, although I know the underlying things that do involve some police reports. Ms. Campbell, what sort of evidence do you have that you would like to submit?
I have the police report from that day, that she said, with the eggs throwing. I have that evidence, and I also have the evidence when she came to my house with her and her daughters, and I also have evidence. She's saying the stuff about with her daughter. That's have nothing to do. That's why she's
Yeah, it's a separate case. I get it.
so,
I'm not
and she
considering
keep
that.
it's nothing. I don't have now she brought this among herself, and then two, you're a judge. You can go to CPS. You can go to
Well, you
CPS
might
and
think
see.
that a lot of people think it's that easy, but the truth is I don't really have much better access to CPS and records of that sort than any other person does. I'd have to obtain releases and all that stuff. And the truth is, in the context of a
Well, I
personal
have the
protective
proof.
order, we don't typically do it that way.
Well, I have the allegations and the reports and stuff, and the stuff that her daughter is saying too, because basically her daughter is coaching her.
Okay. Well, I mean, if it's attributed to her and you think I should read it during the hearing or advance of the hearing, you
Okay,
can submit it to me. I'll take a look at it, and then I'll
okay,
try to make the best decision I can at the next hearing. And any documents or evidence that you want to submit, we can take scanned copies or photos by email, and we can also you can drop off any copies you have or discs or thumb drives can go to our PPO office and they'll get them up to me. So I'll give you both those options. And Lisa has the job of pulling all that evidence together so I can look at it before the next hearing.
All right, that's where things stand for now. The hearing ended without a final decision, but it sounds like the alleged victim will get another opportunity to submit the video evidence she says she has. Once that happens, the court should finally decide at the next hearing whether the protective order stays in place or gets thrown out. Now it's time to move on to our next courtroom train wreck, a defendant who apparently has absolutely no survival instincts. Instead of keeping quiet and helping his own case, he spends the hearing mouthing off and insulting the only person actually trying to help him, his own attorney. This is going to go exactly how you think it will.
Sir, in the Nisqually Jail, good afternoon. What is your name, please?
Matthew Thorne.
Mr. Thorne, you are before the court for a fourth pretrial conference in your case. It appears that you were last scheduled to be before the court on June 13th, 2024, at which time the docket indicates you failed to appear and a warrant was issued for your arrest. This is your first appearance since the service of that warrant. Ms. Arnold, how would you like to proceed with Mr. Thorne's pretrial conference at this time?
Yes, Your Honor. I just want to confirm with the defendant quickly that he was able to go over the SOC with Mr. Reardon over the phone.
Yes.
Okay. And you have no questions about that?
I mean,
If you have any questions, we can go in a breakout room and you can ask me. I just want to make sure that everything was gone over with you prior to going on the record.
I don't agree. I don't agree with any of this, but I don't really feel like it matters. I'm just trying to get it done in the least way possible.
Mr. Thorne, so I have to state that anything that you say can and will be used against you at trial later on if that's what you decided to do. So if you have any questions or concerns or anything, that we could go into a breakout room, okay? So I think going in a breakout room would be appropriate, Your Honor.
Questions? I just want to get out of jail. So it don't really matter.
Thorne, if we could please go in a breakout room.
Of course. Mr. Thorne, you're going to be receiving on the screen there in front of you an invitation to go into a breakout room so that you can speak privately with Ms. Arnold. Please accept that. After the two of you have completed your conversation, we can proceed with this case.
Set it up this way. So I'm going to plan to stay in jail for a while then.
Mr. Thorne, everything that you state can be used against you at trial. So please refrain from stating anything on the record.
It goes to will, man, and I know that. But you know that too. Ever since the day one.
Thorne, please.
No. You guys are just gonna keep me in jail? For what?
Mr. Thorne, please.
Madam Clerk, the city is this still being recorded? The city's requesting. Oh, is it possible for the city to obtain a copy of what was just said? Okay, thank you. And given the defendant's statements, the city is asking that we go back on the record. Even the city won't make any statements, but I would like to have a clear and accurate recording. If anything else is said before the judge comes back, we could go back on the record so this can be recorded.
I want to know why the police didn't get my witness statements. So this is all a joke. You guys aren't here for my interest. No one's here to help me. It's a lie.
Mr. Thorne, please stop stating anything on the record.
I love the irony here. He's sitting there complaining that nobody wants to help him, while his court-appointed attorney is literally doing everything possible to help, mainly by desperately trying to get him to stop talking before he digs the hole any deeper.
You guys are ruining people's lives. For nothing.
Mr. Thorne.
I ain't got shit else good to say. I'm not going to sit here and say what you want me to say. I can't speak my mind.
Oh my God, the judge is back.
And that was bullshit.
Mr. Thorne, please refrain from stating anything else on the record.
Yeah, for my best interest. Sure.
Yes, for your best interest.
Of course. I trust you because I trusted everybody else in this whole situation too.
Mr. Thorne, I understand that you're frustrated and you need to calm down because this isn't great, okay? Please stop saying anything on the record.
I just don't respect you. That's all.
Okay. That's fine, but please protect yourself.
Ms. Arnold, we are back on the record in City of Lakewood versus Matthew James Thorne, 23L000420. Prior to the recess, there was some discussion about a stipulated order of continuance. I now have before me a motion to continue the pretrial conference. Is that correct?
Yes, Your Honor. So it was my understanding that it was going to be a motion to continue, but after speaking with the defendant, I think it is best to continue this case until Monday to allow some time for the defendant to think about this offer.
Okay, that's fair.
I
Mr.
don't have nothing to
Vincent,
think about.
any objection to continuing this matter to Monday at, looks like
Yes,
Monday
me.
at 1
I
p.m.
object.
We're maintaining the bell.
You're not going to keep me in jail an extra 5 days just to make me think, oh, okay. No.
Mr. Thorne, I'm going to need you to try and control yourself so that I can hear from the attorneys, okay?
They're both liars.
Mr. Vincent, what is the city's recommendation?
The city's recommendation that bail be maintained and this could be set over to Monday.
And Ms. Arnold, do you want to be heard on that?
No, Your Honor, that's an agreement.
All right. So we will go ahead and maintain pretrial conditions of release in this matter, and we will set this case over to a new pretrial conference on Monday at 1 p.m. Mr. Thorne, thank you. You can go ahead and let the officer know that your hearing is done. We'll see you on Monday.
Okay, I don't agree. I don't want her to be here on Monday. I want a different lawyer. If I'm going to be in jail, I might as well not play the little game according to your guys' rules. You're not going to fuck me and make me say thank you for it. And get these bitch ass motherfuckers off the screen now. They want to go talk to someone else and lie to someone else.
Your Honor, can defense request a brief recess?
No, we don't need no recess. Fuck you, bitch. Get off the case. That's what we requested now.
Yeah, go ahead and mute the jail. Yes, Ms. Arnold, we can absolutely take a brief recess. Just let me know when you're ready to resume.
Thank you.
A tiny amount of self-control would have saved this guy a whole lot of trouble. Surprisingly, though, when he came back the next day, he actually seemed to figure that out. The hearing itself was mostly procedural, so there's not much worth showing, but for once he made the smartest decision available. He kept his mouth shut and let his attorney do the talking. Now, whether that newfound wisdom lasts longer than 24 hours is another question entirely. If he goes right back to sabotaging himself with another meltdown, you already know I'll cover it. But for now, we've got one final hearing to get through today, and this one features a squatter who apparently believes that if you ignore eviction notices long enough and dodge being served, your legal problems just disappear into thin air. Unfortunately for him,
Case 241-273 LT, Tanju Estambulo versus Cleo Jerome Daniels, appearance of record.
Marissa Boyle, P86438 on behalf of plaintiff.
All right, Mr. Daniels, state your name for the record.
Cleo Daniels.
So, Mr. Daniels, you filed a motion to state the proceedings. You're saying that you don't understand what's going on with this
No.
minority pay.
Yes, sir. I've been here since September of last year. I've been paying my rent. I guess it was several notices that was sent here to the address for me, but the landlord has the key to the mailbox because we have our own separate mailboxes, and he wouldn't give me a key to the mailbox. So all of my mail, I guess, was going back to the court from you guys. I never got a notice. I came in, and the lady at the desk where I filed the motion or whatnot, she verified that all the mail had came back to me, and I really don't understand what's going on at this point. So she told me to file a motion and to get in front of you and find out what's going on because you could be able to explain it better than she could.
I do got notices coming back to him. Do you have any proofs of service, Ms. Wells?
Yes, I could get them.
All right, I'm inclined to send this back to Gubo because I do see multiple returns coming back to the court from that address. Let's see, I don't even see a proof. It was posted by Jason Duncan on July 10th, 2024 at 12:39 on the main interest of the tenants or tenants dwelling unit. Summons and complaint. So you didn't see that, Mr. Daniels?
No, sir. It's a door. It's one door right there in the front, and then you go up to my door. It was never on my door, and I don't know if the person downstairs took that off of the door. But I didn't see it myself personally, and the landlord knows that I can't get the mail because he has the key to get into my mailbox. If I would have seen it, I would have been. If I would have seen it, I would have been, in court the first day. Like I said, I don't understand what's going on right now. My bills, my rent has been paid from November of 2023 to July of 2024. I have text messages with the landlord telling me where to drop it off at. And, me and him having texts about he needs to come into the apartment to do inspections.
Okay.
So,
all right. I'll send it back to Gubo.
You'll send it to where, sir?
I'm going to grant the motion.
Okay.
And proceeding. And you need to come to court and pick it up.
Your Honor, would it be okay if I had the attorney of record get on the matter and make a statement really quick?
He can, but if he's not receiving the notices, unless he can give me tangible, clear, and convincing evidence that he's receiving his notices, I don't. Because I have multiple returns back in my file. But you can get them on. I'll give you time to get them on.
All right. Thank you. He's going to sign it right now.
So at this point, the judge actually seemed ready to grant the motion based on the testimony provided and the fact that the certified mail had been returned after being refused. But then the attorney officially representing the other side stepped in with new information, and the moment that happened, the entire tone of the hearing changed instantly.
Sorry, Your Honor. I was driving from Grand Rapids.
Okay. We can go back on the record in Mr. Daniels' case.
Yes. Stephen Mamet on behalf of the plaintiff, Your Honor.
Go ahead.
Your Honor, the individual who is here has been a squatter for several months. There's alleged drug activity in the house. From what I understand, he's alleging that there's no service and has documents. The documents were served by the court officer in this court. There were several court dates. No one's appeared at any of the court dates, Your Honor. This is not. I don't know what else we could have done. We actually filed it with the court, and the court officer serves it by posting. We posted it on the door. He should have been well aware. This idea about mailings and all this, that if he's of that than he knows about the court. And so that's he's not even a tenant.
Yes, I am. I have a lease, and I have a lease, and I also have text messages from me to the landlord, from him telling me where to go drop the rent money off at, that he needs to give me a 24-hour notice to come in to put in fire extinguishers, to put in
hold on, Mr. Daniels.
Yeah.
Let me ask you this, dude. Is it $8,195 he owes?
No, I don't owe. I only owe for the month of August and September of this year.
Your Honor, there was multiple court dates. The officer of this court posted it on his door.
No,
there was many court dates, and to come in once the bailiff posts it for 24 hours. This is a completely frivolous motion. It has no basis, and it's a waste of the court's time. He has not paid any rent, and to come in now at the 11th hour, once the bailiff posts, because he's about to come in, is ridiculous. It hasn't been.
All right, so, yeah, I agree, Mr. Burnett.
Excuse me, hold on for a second, Your Honor.
Mr. Daniels, the motion is denied. I'm all set.
May I speak, Your Honor?
I've heard enough. The motion is denied. Thank you.
Thank you, Your Honor.
Why is the motion denied, Your Honor?
The court ultimately found that the prosecution followed the proper Michigan court rules when serving you. And just because you claim you never received the paperwork doesn't automatically erase the fact that service was completed legally. At the end of the day, the judge is far more likely to trust the documentation and testimony from a court officer than the excuses coming from someone already facing an eviction case. Maybe the better strategy next time is paying the rent on time instead of trying to dodge service and hoping the entire situation somehow fixes itself if you ignore it long enough. That approach usually just makes the problem bigger and smellier. Alright everyone, that's going to do it for today's video. If you enjoyed it, make sure to hit the like button. If not, feel free to hit dislike. Either way, drop your thoughts in the comments below, and don't forget to subscribe with notifications turned on so you don't miss any future courtroom chaos.